last year, software vendors have aggressively marketed generative AI to understaffed police departments, selling the technology as a long overdue force multiplier for administrative work. But the first major institutional pushback against this deployment has already arrived in Seattle. In September 2024, the King County Prosecuting Attorney's Office issued a strict directive. They announced they will no longer accept police reports generated with the assistance of artificial intelligence. The ban was triggered by a specific fatal error caught during a trial run. An AI reporting system hallucinated a detail, inventing the presence of a police officer who was never actually at the crime scene. Saving an officer 2 hours of paperwork at the end of a shift comes with a severe trade-off. Introducing fabricated evidence into a legal proceeding threatens the entirety of a prosecution. Generative models are built to write compelling copy. Force that creative engine to meet the rigid demands of criminal procedure, and the structure fractures. The root of this problem lies in the dictation fallacy, the assumption by police administrators that generative AI is simply an advanced speech-to-text tool. Traditional transcription is a linear, one-to-one transfer of data. It converts recorded audio directly into text, and it lacks the underlying mechanics to invent novel information. This diagram illustrates the technical reality. On the left is standard transcription. On the right is a probabilistic language model. Its primary function is predicting plausible word sequences, not recording objective truth. When a probabilistic model receives degraded or incomplete input data, it does not leave a blank space. It actively generates a new artificial node to bridge the gap. In computer science, this generative bridging action is known as a hallucination. A hallucination is very different from a human typo. A human might misspell a street name. An AI hallucination produces entirely false information wrapped in flawless grammar and a highly confident tone. Because the output reads so naturally, these fabricated details blend seamlessly into official, formatted documentation. Treating a probabilistic engine as a simple transcription tool guarantees that systemic, invisible errors infect the evidentiary chain the moment the report is drafted. Frontline police work is chaotic. The audio data captured by a body-worn camera reflects that physical reality. The recordings are filled with acoustic obstacles. Suspects and victims speak over each other, wind hits the microphone, sirens blare in the background, and physical scuffles muffle the audio. A generative algorithm processes this noise not as an endpoint to leave blank, but as a prompt to actively guess the missing context. These guesses carry high stakes. An algorithm trying to make sense of a muffled audio track can misidentify the presence of a weapon or invent suspect dialogue out of thin air to complete a sentence. If two distinct speakers are talking simultaneously, the algorithm frequently merges their voices, fabricating a single combined statement that neither person actually said. These fabrications strip away the nuance and context required to conduct a fair and constitutional investigation. The justice system relies entirely on the first-hand observations of sworn officers. An algorithm that prioritizes narrative flow over factual accuracy corrupts that foundation. Tech vendors defend their products by pointing to human oversight. Their policy requires an officer to review and sign off on every AI-generated draft before it is submitted. This defense ignores a well-documented psychological vulnerability known as cognitive offloading. This diagram represents the traditional report writing process. A human brain actively lights up, executing a high-effort mental reconstruction to assemble separate fragments of an event into a timeline. When you introduce an AI draft, the human shifts from an active creator to a passive, low-effort editor. The authoritative tone and perfect grammar of the algorithm artificially lower the human reviewer's natural skepticism. Errors easily clear the mental checkpoint. Consider a Fourth Amendment search. If an AI hallucinates a proposition, stating that contraband was found inside a closed glove box instead of on top of it, the legal justification for probable cause is destroyed. Or consider consent. If an AI mistakenly attributes verbal permission to search a vehicle to the owner instead of a passenger, the evidence collected in that search becomes inadmissible. If a defense attorney proves on cross-examination that the officer on the stand did not actually author the specific words in their own report, the officer's credibility collapses. Cognitive offloading neutralizes the human accountability layer. It turns a sworn officer into a blind rubber stamp for an algorithm's probabilistic guesses. The danger amplifies during the discovery phase of a criminal trial, governed by the Brady Rule. Under Brady, a defendant has a constitutional right to examine exculpatory evidence, as well as the underlying methods used by the state to produce that evidence. A competent defense attorney will inevitably demand the AI's audit trail to verify exactly how a contested, hallucinated fact made its way into the official record. This flowchart illustrates the technological roadblock. The discovery request hits an impenetrable wall. Generative AI tools are proprietary black boxes, protected by corporate trade secrets. It is mathematically impossible for the prosecutor to prove exactly how the AI weighted its internal data to produce the hallucinated sentence. The mechanics are entirely hidden. This black box architecture creates a secondary danger. The software absorbs irrelevant, private background conversations and stores that data on external corporate servers. Introducing an unauditable, proprietary black box into a judicial system built entirely on transparency creates a fatal constitutional dead end. The liability extends far beyond police departments. Attorneys handling these tainted documents or using AI tools to generate casework face severe professional exposure. The American Bar Association's Model Rule 1.1 dictates the strict professional duty of competence. Under this rule, lawyers must fully understand the operational risks, limitations, and mechanics of any technology they deploy for their clients. The definitive warning for the legal profession occurred in Mata v. Avianca. In that case, attorneys submitted a brief to a federal judge containing fabricated, AI-hallucinated case law. They failed to verify the probabilistic output, and they were heavily sanctioned. We are also seeing civil liability emerge in cases like Walters v. OpenAI, where an AI hallucinated a fake embezzlement lawsuit against a radio host, triggering a direct defamation claim. A lawyer's ethical duty of candor to the tribunal cannot be delegated to software. Relying blindly on an AI means assuming the full legal and financial weight of its fabrications. The friction is irreconcilable. A probabilistic tool prioritizes narrative efficiency, while the legal system requires absolute factual accuracy. Attempting to use "the chatbot said so" as a legal defense will instantly collapse in front of any judge. The professional consequences are severe and permanent. Rule 11 court sanctions, malpractice lawsuits, and the total destruction of public trust. You cannot cross-examine an algorithm. Active, rigorous human oversight remains non-negotiable. Deploying generative AI without extreme evidentiary safeguards does not eliminate the workload. It merely transforms a routine administrative task into a catastrophic professional liability.